Seems to go live. That's great.
Venue in California state courts. Where is it? Is this what I'm doing? No. All right. So, I don't know if these are distinguishing traits in part A, B, or C, and D, because there's not much written, but I do know that much of this are different from federal Civ Pro, and at least as it relates to like limited, unlimited, and small claims cases, case classifications. Amount of controversy, there's really nothing written there. And reclassification of the original classification probably is limited, unlimited, and small claims. Just having a little bit of experience with this in practice has helped. You would motion for reclassification from unlimited to limited, and a standard for reclassification from limited to unlimited, and other means of reclassification is an amended complaint, a cross complaint, limited civil case complaint, and unlimited civil case complaint. So these are all totally different from federal civil procedure that only exists probably in California or states that want to be like it. Personal jurisdiction sections say that, and as a high-level overview, personal jurisdiction must be constitutional and authorized by statute. So I almost believe the long-arm statute authorizes personal jurisdiction to constitutional limits, and I say that, but it's written right here under statutory authorization. So that's how California is organized in terms of long-arm statutes over non-residents. Jurisdiction over the non-residents. Venue in California state courts. The proper court, the transfer or change of venue, forum and venue selection clauses, and forum non-convenes. So the requirements, the timing of the motion for forum non-convenes is really all that's written here. So there's nothing written under forum and venue selection clauses. And the proper court, what it's saying is local actions, transitory actions, under which there's actions against individual defendants, actions against corporations, associations, and partnerships, main relief rule, and mixed actions. For transfer or change of venue, there's transfer for improper venue and change of venue on other grounds. Conflict of laws is going to be the 9th section of this outline. And California's conflict of laws rules in tort actions and contract actions. So for tort actions, the governmental interest approach is listed. In contract actions, it's the choice of law clauses probably that prevail. Pretrial and trial procedures, commencement of the action under which is listed only one thing, the statute of limitations in California courts. A, accrual of cause of action, and B, tolling of statute of limitations. The service of process of who can serve, party served within California is Part B under pretrial and trial procedures. Notice and acknowledgement of service is the last, or is the only note under parties served within California. And then parties served outside the state but within the United States, parties served in a foreign country, and no immunity from process. So the last part's under service of process. Part C of trial, pretrial, and trial procedures. Part C is pertaining to interlocutory injunctions. Part D revolves around pleadings, joinder of parties, joinder of claims, discovery, pretrial conferences, alternative dispute resolution, dispositive pretrial motions and procedures, And then we get to trial, the outline for trial, and general sanctions for frivolous actions or tactics would be the last part, but there's really nothing under that part of the outline. So this is just such a high-level outline that I can't speak to the nature of anything in any of these sections besides just naming the section by title. But it's good just scrolling through to see what's involved. So I'm going to read what two interlocutory injunctions there are is preliminary injunction and temporary restraining order. There's 4 parts under temporary restraining order, which is probably where there's some differences in California. Worth noting is requirements for ex parte TROs 1, 2, and 3, specific facts showing immediate and irreparable injury, efforts to give notice, security, notice of hearing versus actual notice, discretion of court, and time limit are the other parts of TRO. Pleadings, I'm just going to read them. First, there's a complaint. There's nothing else beneath that. Then there's challenges to the complaint and the answer. Within challenges to the complaint, there's A through G. A is the demur. So California's retained the demur terminology, including the following 4 types: general demur, special demur, meet and confer, and ruling on demur. The other challenges to the complaint include motion for judgment on the pleadings, motion to quash service of summons, motion for forum non-convenes, motion to transfer or change venue, motion to strike, and the anti-SLAPP motion to strike. And under anti-SLAPP, there's restricted use of anti-SLAPP motion and slap back suits. Answer, general and specific denials permitted and time. The third part under answer is effective failure to answer default and default judgments, entry of default judgment entered by the clerk, default judgment entered by the court, setting aside a default or default judgment. So I have some experience with amending complaints and default judgments and entries of default and service, actually. I've also seen these DOE amendments. In reality, I'm seeing the terminology limited and unlimited on a complaint. So I'm in a much better place the second time taking the bar than I was the first time, where I had never seen this terminology ever before studying for the bar. 4th part of pleadings is the cross complaint. 5th, alternative pleadings. 6, pleading facts. 7, amended pleadings. 8, certification upon presenting paper to the court, which consists of the sanctions on the court's initiative and upon another party's motion. And then for amendments to pleadings, there's 3 parts: amendment to add a new cause of action against a defendant already named, the California DOE amendments, and to conform to evidence. Joinder of parties, compulsory joinder, should the absentee be joined? Can the absentee be joined? Should the action proceed without the absentee? And permissive joinder. Joinder of claims, the first part above interpleader and intervention is the class actions in California state courts. Opting out, Part B, notice. Part C, aggregation of claims. Part D, settlement and dismissal of claims. Part E, representative suits. Again, there was interpleader, intervention. Intervention is a right, permissive intervention, and there's a Part C is caveat. And third-party practice impleader, there's 4 parts: claims for indemnity, non-indemnity claims, severance of third-party claims, response of third-party, and cross-complaint against a co-defendant. Then there's the discovery section, initial required disclosures, supplementing initial disclosures. Part 2, scope of disclosure and discovery regarding relevance, work product protection privileges, California right to privacy, protective orders, discovery of ESI, objections to production, inadvertently produced ESI, and F, supplementation of disclosures and discovery responses, timing of discovery, and 3, beginning with pre-action discovery, beginning of discovery, and completion of discovery. Methods of discovery, oral deposition of a witness, including a party witness. What else is there? Deposition of witnesses on written questions, interrogatories to the parties, often used. Production and inspection of documents and things, physical and mental examinations, the order for examination, who may conduct the exam, requests for admission, and experts. So just kind of opening up for depositions of witnesses on written questions. A corollary to that is objections as to form of written questions. Under the under methods of discovery, oral deposition of a witness, including a party witness, within this oral deposition of the witness and party witness, there's limits on depositions, use of depositions at trial or hearing, errors and irregularities on depositions as to the notice, as to the manner of the taking, as to the completion and the return. Part B, deposition of witness. I said that. So moving on is enforcing disclosure and discovery. There's a motion to compel disclosures and discovery. I believe I worked on that, including discovery sanctions. Worked on one of those too. Discovery in limited civil cases and pretrial conference. Case management conference, fast track, and additional conferences, as well as sanctions under the trial conferences section. Alternative dispute resolution, there's contractual arbitration, judicial arbitration, and mediation. The procedure for contractual arbitration is a judicial review of the award. Dispositive pretrial motions and procedures, there's involuntary dismissals, failure to diligently prosecute, other grounds for involuntary dismissal. Voluntary dismissals, costs and offers of judgment, summary judgment. Standard of summary judgment is broken into burdens, time, summary adjudication, support, affidavits, non-appealability, and relationship to general demur, and motion for judgment on the pleadings. Then entering in the trial, section K is the jury trial, the jury demand and right to jury trial, which is composed of one, source of jury trial right, when the jury trial right exists, and expedited jury trial. There's under jury trial is the jury size and composition, jury instructions, and jury verdicts. There's 6 kinds: general verdict, special verdict, general verdict with special interrogatories, jury deliberations, erroneous verdicts, juror misconduct. The other parts of the trial include consolidation and separate trials, motion for non-suit and motion for directed verdict, motion for judgment notwithstanding the verdict, motion for new trial, which is broken into reasons for granting a new trial, remediator, auditor, or what it says here, next to editor is California state courts only, so not the federal courts. Of course, that follow the federal rules of civil procedure. And effective failure to move for a JNOV or for a new trial, and trial by court. Then there's general sanctions for frivolous actions or tactics, which I said before. To close out section 5, which had to do with pretrial procedures and trial procedures, right? And then part 6 in this really level outline, I might even just print it out, is attack on judgments and orders at the trial court level. There's only one section in here called relief from judgment or order. There's 4 kinds: clerical mistakes, defendant not personally notified, motions to reconsider prior orders or renew prior motions, and 4th, other grounds for relief from the judgment. Subpart 7, final judgment and appellate review. Part A, judgment, relief. 1, relief that may be given. 2, judgment on multiple claims or parties. Time for appeals. That doesn't have any subparts. And review for orders and judgments. There are 4 parts under the review of orders and judgments. Those include interlocutory judgments, collateral order rule, review of non-appealable orders by writ, certification of class actions. Stay pending appeal in two parts is execution and enforceability. Part 2, effective appeal. And then subpart E, civil jurisdiction of California Supreme Court. The effects of judgment on future cases really ought to be the last section, as it always is. There's claim preclusion, re judicata, and issue preclusion, collateral estoppel. But in California, they're very different. So the introduction to claim preclusion is part 1. Part 2 is requirements for merger and bar. The California distinctions is on the merits. California distinction is also definition of final judgment. Cause of action will be defined. The California distinction will be primary rights doctrine. And the common examples are accidents under primary rights doctrine and installment obligations under primary rights doctrine. And for issue preclusion, there is only one important note: non-mutual issue preclusion. And that's going to be it for this high-level overview of what we're going to discuss in the next 4 hours of California civil procedure. What did July? Just took 15 minutes to outline